Question 1. What is the purpose of a retainage or retention clause in a construction contract? Is it A, to pay subcontractors before the general contractor? B, to fund project contingencies? C, to compensate the owner for delays? D, to allow the owner to withhold a portion of payment until project completion? The correct answer is D, retainage. Typically 5 to 10% of each progress payment is withheld by the owner as security until the project is substantially complete and defects are corrected. It motivates timely completion. Question 2. A contractor's current ratio is 0.8. This means, is it A, the company has 80 cents in current assets for every $1 in current liabilities? B, the company has more current assets than current liabilities? C, the company is highly liquid? D, the company has an 80% profit margin? The correct answer is A, current ratio equals current assets divided by current liabilities. A ratio below 1.0 means current liabilities exceed current assets, a potential liquidity problem signaling the contractor may struggle to pay short-term debts. Question 3. Before starting a project, a contractor should prepare a schedule of values in order to, is it A, calculate the contractor's overhead rate? B, establish milestone payment amounts tied to completed work? C, determine subcontractor licensing requirements? D, set the overtime schedule for workers? The correct answer is B. A schedule of values breaks the contract amount into line items by trade or work phase. It becomes the basis for progress payment requests, AIAG 702/703, ensuring payments match completed work. Question 4. A contractor receives a $5,000 deposit on a contract. Under California law for home improvement contracts, the maximum down payment is it A, $500 or 5%, whichever is less? B, $2,500 or 15%, whichever is less? C, there is no legal limit on down payments? D, $1,000 or 10%, whichever is less? The correct answer is D. California law limits down payments on home improvement contracts to the lesser of $1,000 or 10% of the contract price. Demanding more is a violation of the contractor's state license law. Question 5. Which of the following best describes overhead in construction estimating? Is it A, direct labor costs on a project? B, profit added to the job cost? C, material costs for a specific project? D, indirect costs of running the business not tied to a specific job? The correct answer is D. Overhead includes indirect costs like office rent, utilities, insurance, equipment depreciation, and administrative salaries, costs incurred to keep the business running regardless of any specific project. Question 6. Under California law, a home improvement contract is required for residential work when the total contract price, labor and materials, is at least, is it A, $200? B, $500? C, $1,000? D, $2,500? The correct answer is B. California requires a written home improvement contract for any work on a residential property totaling $500 or more, including both labor and materials. Question 7. A homeowner can cancel a home improvement contract that was solicited at their home within, is it A, 24 hours? B, 3 business days? C, 5 business days? D, 7 calendar days? The correct answer is B. The 3-day right of rescission applies to contracts solicited and signed at the consumer's home. The homeowner has until midnight of the 3rd business day to cancel without penalty. Question 8. Which of the following must be included in a California home improvement contract? Is it A, architect's stamp? B, a list of all subcontractors? C, contractor's license number and expiration date? D, a performance bond number? The correct answer is C. California law requires home improvement contracts to include the contractor's name, address, license number and expiration date, description of work, project start and completion dates, and payment schedule. Question 9. A contractor and homeowner agree to change the scope of work during a project. This agreement must be, is it A, verbal, confirmed by a handshake? B, written and signed by both parties before work begins? C, approved by the local building department? D, filed with CSLB within 10 days? The correct answer is B. All changes to a home improvement contract must be documented in a written change order signed by both the contractor and homeowner before the changed work begins. Question 10. A contractor may demand final payment from the homeowner. Is it A, upon substantial completion of the project? B, when 50% of the work is complete? C, after all materials are delivered to the site? D, at the start of the project? The correct answer is A. A contractor may not demand or accept final payment until the project is substantially complete. Demanding payment before this point is a violation of California contractors' law. Question 11. Which statement about arbitration clauses in construction contracts is true? Is it A, they are illegal in California? B, they can be included but must be clear and conspicuous? C, they are required in all home improvement contracts? D, they automatically waive the right to a jury trial in all cases? The correct answer is B. Arbitration clauses are permitted in construction contracts but must be clearly disclosed, written in at least 10-point boldface type in home improvement contracts, and separately initialed by the homeowner. Question 12. A contractor abandons a job without justification after receiving a substantial deposit. The contractor may face, is it A, civil fine only? B, only a requirement to refund the deposit? C, license suspension or revocation and criminal charges? D, a warning letter from CSLB? The correct answer is C. Abandonment without legal excuse exposes a contractor to license discipline, suspension/revocation, civil liability for breach of contract, and potentially criminal charges for misappropriation of funds. Question 13. Who is primarily responsible for obtaining building permits on a construction project? Is it A, the property owner? B, the architect? C, the local building department? D, the prime contractor? The correct answer is D. While permits can technically be pulled by the owner, it is the contractor's professional responsibility to ensure all required permits are obtained before work begins. Working without required permits is a license violation. Question 14. A contract clause that shifts responsibility for delays outside the contractor's control to the owner is called, is it A, a force majeure clause? B, a liquidated damages clause? C, an indemnification clause? D, a no damage for delay clause? The correct answer is A. A force majeure clause excuses a party from performance when extraordinary events beyond their control, weather, acts of God, pandemics, prevent timely completion. It protects the contractor from delay damages. Question 15. An owner includes a liquidated damages clause of $500 per day for late completion. This clause is enforceable if, is it A, the amount represents a reasonable estimate of actual damages at the time the contract was signed? B, the amount is very high to punish the contractor? C, it is approved by CSLB? D, the contractor waives their right to arbitration? The correct answer is A. Liquidated damages are enforceable if 1. Damages were difficult to estimate at contract signing, and 2. The amount is a reasonable estimate of probable harm, not a penalty. Question 16. A contractor must provide an owner with a notice to owner, preliminary notice, primarily to, is it A, inform the owner that work has begun? B, comply with building permit requirements? C. Preserve the right to file a mechanic's lien if not paid. D. Register the contract with the local court? The correct answer is C. The preliminary notice is not a demand for payment. It preserves the right to file a mechanic's lien later if the contractor or supplier is not paid. Without it, lien rights may be lost. Question 17. Under a time and materials (T&M) contract, the owner pays, is it A. A fixed price agreed upon before work starts? B. Only the material costs, labor is the contractor's responsibility. C. A set hourly rate with no material reimbursement. D. Actual costs of labor and materials plus an agreed markup or fee? The correct answer is D. A T&M contract pays the contractor for actual labor hours at an agreed rate plus actual material costs, typically plus overhead and profit markup. The total cost is not fixed in advance. Question 18. Which contract type places the most financial risk on the contractor? Is it A. Cost plus contract? B. Fixed price, lump sum, contract? C. Time and materials contract? D. Unit price contract? The correct answer is B. Under a fixed price, lump sum, contract, the contractor agrees to complete the work for a set price regardless of actual costs. If costs exceed the estimate, the contractor absorbs the loss. Question 19. A subcontractor fails to complete their scope of work on a project. The prime contractor's primary recourse is it A. File a complaint with CSLB? B. Withhold payment and hire another sub to complete the work, then sue for the cost difference? C. Abandon the entire project? D. Request a change order from the owner? The correct answer is B. The prime contractor can withhold payment from the defaulting subcontractor, hire a replacement to complete the work, and sue the original sub for any additional cost incurred above the original subcontract price. Question 20. California's prompt payment law requires owners to pay general contractors within how many days of a proper invoice? Is it A. 7 days? B. 30 days? C. 45 days? D. 60 days? The correct answer is B. On private works, owners must pay general contractors within 30 days of a proper undisputed invoice. On public works, the period is 30 days from invoice or 39 days from billing, depending on the agency. Question 21. A general contractor must pay a subcontractor within how many days of receiving payment from the owner? Is it A. 3 days? B. 7 days? C. 10 days? D. 30 days? The correct answer is C. California prompt payment law requires general contractors to pay subcontractors within 7 days of receiving payment from the owner for private works, and 10 days for public works. Question 22. A contractor is hired to build a room addition. After completion, the homeowner claims defects. The contractor's written warranty on new residential construction must be at least, is it A. 90 days? B. 1 year? C. 2 years? D. The contractor sets the term freely? The correct answer is B. California's Right to Repair Act, SB 800, establishes statutory warranties for new residential construction, 1 year for most components, 4 years for plumbing/electrical/mechanical, 10 years for structural defects. Question 23. A subcontractor begins work on a private project on March 1st. To preserve lien rights, the preliminary notice must be served by, is it A. March 1st? B. March 21st? C. April 1st? D. Within 20 days of first furnishing labor or materials? The correct answer is D. On private works, preliminary notices must be served within 20 days of first furnishing labor, services, equipment, or materials. Serving late does not eliminate lien rights entirely but limits them to work performed within 20 days before service. Question 24. A preliminary notice on a private construction project must be served on, is it A, the owner, prime contractor, and construction lender, if any? B, the prime contractor only? C, the building department? D, the CSLB and the prime contractor? The correct answer is A. Preliminary notices must be served on the owner, the prime contractor, and the construction lender, if any. Serving all three is necessary to fully protect lien and stop payment notice rights. Question 25. After completion of a private project, a claimant has how many days to record a mechanic's lien if no notice of completion is filed? Is it A. 30 days? B. 60 days? C. 90 days? D. 180 days? The correct answer is C. If no notice of completion or cessation is recorded, a mechanic's lien must be recorded within 90 days of completion of the project. This is the maximum window for lien claimants. Question 26. If the owner records a notice of completion, subcontractors and suppliers must record their mechanic's lien within, is it A. 30 days? B. 45 days? C. 60 days? D. 90 days? The correct answer is A. When an owner records a notice of completion, subcontractors and material suppliers, who are not the direct contractor, have only 30 days to record their mechanic's lien. The prime contractor has 60 days. Question 27. After recording a mechanic's lien, the claimant must file a lawsuit to enforce the lien within, is it A. 30 days? B. 60 days? C. 90 days? D. 1 year? The correct answer is C. A recorded mechanic's lien expires unless the claimant files a lawsuit to enforce it within 90 days of recording. Failure to sue timely renders the lien void. Question 28. What is the purpose of a stop payment notice on a private construction project? Is it A. to require the owner or lender to withhold funds from the contractor? B. to halt all work on the project? C. to record a lien on the property? D. to notify the building department of a payment dispute? The correct answer is A. A stop payment notice, formerly stop notice, requires the owner, lender, or public entity to withhold sufficient funds from the prime contractor to satisfy the claimant's unpaid claim. Question 29. An owner can release a recorded mechanic's lien by obtaining a lien release bond equal to, is it A. 100% of the lien amount? B. 150% of the lien amount? C. the exact lien amount plus 10% interest? D. 125% of the lien amount? The correct answer is D. To release a mechanic's lien from a property, the owner or contractor can record a lien release bond equal to 125% of the lien amount. This shifts the claimant's security from the property to the bond. Question 30. Which of the following is not required to be included in a mechanic's lien? Is it A. claimant's name and address? B. social security number of the claimant? C. description of the work performed? D. amount of the claim? The correct answer is B. A valid mechanic's lien must include the claimant's name/address, employer/employee info, description of work/materials, amount of claim, description of the property, and owner's name. No SSN is required. Question 31. On a public works project, a claimant who did not serve a preliminary notice can still file a, is it A, mechanic's lien? B, stop payment notice against the public entity? C, both a lien and stop payment notice? D, either. Preliminary notice is mandatory on public works? The correct answer is B, mechanic's liens cannot be recorded against public property. However, on public works, unpaid claimants can serve a stop payment notice on the public entity to hold project funds. Question 32. A general contractor typically has how many days after a notice of completion is recorded to file a mechanic's lien? Is it A, 30 days? B, 60 days? C, 90 days? D, 180 days? The correct answer is B. The prime, direct, contractor has 60 days after the owner records a notice of completion to record a mechanic's lien. Subcontractors and suppliers have the shorter 30-day window. Question 33. The purpose of the preliminary notice requirement is to, is it A, start the project legally? B, establish the contractor's priority over other creditors? C, serve as a demand letter for payment? D, alert the owner to potential lien claimants on the project? The correct answer is D. Preliminary notices protect owners by informing them early who is furnishing labor and materials. Owners can then ensure funds flow properly and avoid paying the general contractor if subs are unpaid. Question 34. A claimant recorded a mechanic's lien but was paid in full before filing a lawsuit. The claimant must, is it A, leave the lien on the property indefinitely? B, file a notice of completion? C, record a lien release within 30 days of written demand or payment? D, re-record the lien to update the amount? The correct answer is C. Once paid, the claimant must release the lien. If the owner makes a written demand, the claimant has 30 days to record a release. Failure to release can result in damages and attorney's fees. Question 35. Which statement about a joint check agreement is correct? Is it A, it is a tool owners and GCs use to ensure subcontractors and suppliers are paid directly? B, it requires CSLB approval? C, it eliminates the need for a preliminary notice? D, it applies only to public works projects? The correct answer is A. A joint check agreement requires checks to be made payable jointly to the GC and subcontractor or supplier. This ensures the sub/supplier actually receives payment and reduces lien exposure. Question 36. California law requires that contractors give residential owners a notice to owner, preliminary notice. What additional notice must contractors give homeowners on home improvement projects? Is it A, a mechanic's lien waiver? B, a notice of right to cancel? C, a lien release bond offer? D, a notice of commencement of construction? The correct answer is B. Home improvement contractors must provide a notice to owner regarding the contractor's right to file a mechanic's lien and a notice of right to cancel informing homeowners of their 3-day rescission right. Question 37. Which document is required for every California employer with one or more employees? Is it A, a written safety data sheet for each chemical? B, an injury and illness prevention program, IIPP? C, a confined space entry permit? D, an OSHA 300 log? The correct answer is B. California Labor Code Section 6401.7 requires every employer to establish, implement, and maintain an injury and illness prevention program, IIPP. This is the foundation of California's workplace safety system. Question 38. Cal/OSHA may inspect a workplace. Is it A, only with 48-hour advance notice? B, only during normal business hours with a warrant? C, only after a written employee complaint is filed? D, without advance notice at any reasonable time? The correct answer is D. Cal/OSHA compliance officers may inspect workplaces without advance notice at any reasonable time. Employers are generally required to grant entry. An imminent hazard inspection may occur at any time. Question 39. At what height above a lower level does California require fall protection for employees in the construction industry? Is it A, 4 feet? B, 6 feet? C, 10 feet? D, 15 feet? The correct answer is B. Cal/OSHA requires fall protection, guardrails, safety nets, personal fall arrest systems, when employees are working at heights of 6 feet or more above a lower level in construction. Question 40. An excavation or trench that is 5 feet deep or deeper must be, is it A, covered with steel plates? B, inspected by the building department only? C, roped off with caution tape only? D, protected with a shoring system, sloping, or shielding, trench box? The correct answer is D. Cal/OSHA requires protective systems, shoring, sloping/benching, or trench boxes, for all excavations and trenches 5 feet or more deep where workers will enter. Unprotected trenches are a leading cause of fatalities. Question 41. A permit-required confined space in construction is one that, is it A, contains or has a potential to contain a hazardous atmosphere or other serious hazard? B, has any opening smaller than 18 inches? C, is deeper than 4 feet? D, requires a key to enter? The correct answer is A. Permit-required confined spaces contain or may contain hazardous atmospheres, material that could engulf a worker, or other serious hazards. Special entry procedures, monitoring, and rescue plans are required. Question 42. Employers must provide safety data sheets, SDS, for all hazardous chemicals in the workplace. An SDS must contain how many sections according to the GHS standard? Is it A, 8 sections? B, 12 sections? C, 16 sections? D, 20 sections? The correct answer is C. The Globally Harmonized System, GHS, requires standardized 16-section safety data sheets, SDS. Cal/OSHA's Hazard Communication Standard, HAZCOM, aligns with this format. Question 43. Under California heat illness prevention regulations, employers must provide outdoor workers with water, shade, and access to cool down rest when the temperature reaches, is it A, 80 degrees Fahrenheit 27 degrees Celsius? B, 85 degrees Fahrenheit 29 degrees Celsius? C, 90 degrees Fahrenheit 32 degrees Celsius? D, 95 degrees Fahrenheit 35 degrees Celsius? The correct answer is B. Cal/OSHA's heat illness prevention standard requires water, shade, and cool-down periods for outdoor workers when temperatures reach 80 degrees Fahrenheit. High heat procedures kick in at 95 degrees Fahrenheit. Question 44. A contractor is cited by Cal/OSHA for a willful violation. This means the violation was, is it A, an accident with no prior history? B, committed knowingly or with plain indifference to the law? C, a first offense with no injury? D, minor and easily corrected? The correct answer is B. A willful violation is one committed knowingly, intentionally, or with plain indifference to Cal/OSHA regulations. Willful violations carry much higher penalties than other violation types. Question 45. Which type of scaffolding requires specific training before workers can erect, disassemble, or use it? Is it A, only scaffolding over 10 feet high? B, all scaffolding regardless of height? C, only tube and coupler scaffolding? D, only suspended scaffolding? The correct answer is B. Cal/OSHA requires that all scaffolding be erected and used under the supervision of a competent person, with specific training for workers. This applies to all scaffolding types and heights. Question 46. Personal protective equipment, PPE, on a construction site must be, is it A, purchased by the employee? B, provided only when OSHA inspects? C, required only for subcontractors? D, provided by the employer at no cost to the employee? The correct answer is D. California requires employers to provide all required personal protective equipment at no cost to employees. This includes hard hats, safety glasses, gloves, hearing protection, and respirators when required. Question 47. An employer must record a work-related injury on OSHA Form 300 log of work-related injuries, if the injury results in, is it A, any first aid treatment? B, only if the employee files a claim? C, injury to more than one employee? D, days away from work, restricted work, or medical treatment beyond first aid? The correct answer is D. OSHA record-keeping requires documenting injuries and illnesses that result in death, days away from work, restricted duty, job transfer, loss of consciousness, or medical treatment beyond first aid. Question 48. What is the primary purpose of a toolbox talk on a construction job site? Is it A, to review the project schedule? B, to conduct formal OSHA training? C, to review payroll with employees? D, to provide brief safety training on specific hazards? The correct answer is D. Toolbox talks, also called tailgate meetings, are short, informal safety meetings typically held at the start of a shift to address specific hazards, near misses, or safety topics relevant to the day's work. Question 49. Which of the following is the employer's responsibility under California's Hazard Communication (HAZCOM) standard? Is it A, train employees on chemical hazards and ensure chemicals are labeled and SDS are accessible? B, provide labels and SDS only for chemicals purchased after 2020? C, post chemical lists in the break room only? D, submit annual chemical reports to Cal/OSHA? The correct answer is A. HAZCOM requires employers to maintain a written program, ensure all containers are labeled, make SDS accessible to workers, and provide employee training on chemical hazards in the workplace. Question 50. A Cal/OSHA compliance officer arrives at a job site. The contractor should, is it A, refuse entry and demand a warrant? B, allow entry, the officer has the right to inspect? C, ask the officer to return the next day? D, immediately call the CSLB? The correct answer is B. Employers are generally required to allow Cal/OSHA compliance officers to inspect their workplaces. Refusing entry without good cause can result in a warrant and additional penalties.